Welcome. Thank you all for participating in California Mediation Week. And today we're talking about real estate, and there's a lot to talk about. We have three wonderful panelists. The first gentleman who will be talking is Noah Stein. Noah has the background and mediation experience in HOAs. That is an animal unto its own. He comes to this with experience of mediating since 2012, has a background in real estate sales and management, corporate business development, strategic planning, and finance. He's also worked in local community organizations and nonprofit management. Our next speaker will be Jack Gannon, and he will be sharing information regarding landlord tenant. Jack comes to mediation with 40 years of experience in corporate America. He was in high-level positions in Pepsi, Disney, House of Blues, and the most recent Equinox Fitness. Jack brings a different view of mediation from the business practical world, and his mission is to turn conflict into resolution. He's done numerous cases in employment, business, and landlord tenant. And our third speaker is Annette Berger. She is the Senior Vice President and Broker Manager for Sotheby's International Realty. She has over 160 full-time agents reporting to her, and she oversees the offices of Channel Islands, Westlake Village, Topanga, and Malibu. She'll be sharing her valuable experience and knowledge regarding what is really happening in real estate regarding the fires. So with that, let's begin.
Thank you, Melinda. So I want to, since we're speaking with the general audience here, I wanted to talk about HOA disputes from this perspective of how, because there's a lot of sort of mystery around it. I want to talk about how the process flow tends to go. Who tends to reach out for mediation, how they tend to go, what some of the general dynamics are. Linda, if you can put us to the first slide. So let me talk first about the common sources of HOA disputes. What you see here probably won't surprise you: board failure or improper fulfillment of duties, maintenance, property, determination of liability for damages. If there's a leak and it damages somebody's unit, who's usually responsible? Is it the HOA or the unit? Imposition of fines, are they being given fairly? What are they for? Design review of projects. Is the HOA being overbearing? How, what do the CC&Rs say? Things like that. Selective enforcement or failure to enforce HOA rules also relates to the imposition of fines question. And then misuse or problematic use of HOA funds, or poor quality of management, or people believing that the quality of management is not good, that type of thing. So these are some of the most common types of disputes that arise between homeowners and the HOA itself. Next slide. So starting off in the workflow. So who do people call when they have a dispute? It varies. They could call an attorney. The HOA could call the attorney. An owner could call the attorney. HOA could call a mediator. Owner could call a mediator. There's different people, and they come at it from a different perspective. Sometimes they think that they want to litigate right away. Sometimes they think that, maybe we can work this out. In general, they more think that they want to litigate. And I'll give an example of that in a minute, but go ahead and move to the next slide. So what happens next? Whoever it is that they're calling, there's sort of and when they're calling me, it's an informal process. They look at what is it that is likely to happen, who tends to have more leverage, what types of power are there? There's the legal power versus situational power, the possible outcomes, the cost of the different outcomes. And when I talk to people, I also talk about not just the financial cost, but the sort of life cost, because especially with HOAs, but certainly with any litigation, but especially with HOAs, there's all of the intertwined relationships. And it depends on who's helping you map. Is it an attorney? They're going to map it sort of in a more legal way, but they will also, a lot of attorneys will make sure that they well, they actually have to make sure that there is at least some attempt to mediate. But I'll give you an example of a call that I got not that long ago, which speaks to, and this is sort of a mapping conversation, and it had them make a decision to just sort of go off on their own. And that was, I got a call from somebody, and they didn't like the way that something was being handled around there were a couple of units that had bed bugs. And so the bed bugs got resolved within a couple of units, and the HOA board decided that wasn't sufficient. They wanted the whole building to be tented. And so the person who called me said, a couple of us don't feel that this is appropriate. It's going to be very expensive. It's overkill and all of that. And we want to recall the board. That's what we want to do. Tell us what it takes to recall the board. And I said, well, okay, so remember, I'm not an attorney. I can, walk you through Davis Sterling. We can take a little look at that. But I can guarantee you that is going to be a significant and painful process. Let me ask you another question. When's your next election? And he paused. And he said, 3 months from now. And I said, okay, well, so that's probably what you want to look at first. And the reason I'm mentioning this now is because that's a theme that really comes up a lot, is that people have a tendency to think immediately of litigation and what the process is about litigation, and there's very little to no awareness about what the sort of relational and leadership processes are that can be engaged. And a lot of times I start working with people in that area because they just don't even think about it. It requires additional thinking, which I'll get to later. But I wanted to list that as sort of a setup example about mapping. So go ahead and go to the next slide. Okay, so one of the things that I also tell people is, and in the world of frequent outcomes, in general, the HOA has more leverage. And again, in sort of that bedbug example, even if the board's ideas or methods are not very good, even if they execute their ideas poorly, and even if they don't have good judgment, they have the leverage and they tend to win because mostly what they do is within their rights. In the bedbug case, even if people don't like it, if they did a certain amount of due diligence and they feel that the building needs to be tented, they're within their rights to say this is how we're going to do it. Even and also because being highly competent is not necessarily a requirement. That's just the reality of HOA boards. The job goes to whoever's willing to take it. And most people know this, but they sort of forget that. And then lastly, because acting as a fiduciary is very broadly defined. And so, the court will say, well, they thought they were doing a good job. So, we're not going to, and there is case history saying that if they were doing their best, that's good enough, So, and people tend not to think about that. So these are sort of the top things that I talk to when people jump in wanting to litigate. And the bedbug story is just such a simple and easy example. Go ahead, next slide. And then frequent outcomes, if it's mediating agreements, you get agreements people can live with. There's a certain level of anguish and funds that are spared. There's still anguish, and there are still some funds that are not spared, but a lot is. And new opportunities arise, and I really do mean this. The community strengthens itself, the relationships are strengthened, And people actually start to understand leaderships and negotiation, which they just didn't before. Again, with the bedbug example, it didn't even occur to him that there was a political or relational solution to it. So even if no one loved the outcome, because that's the thing, a lot of mediation is what can you live with? You know, it's still worth it, but you're probably not going to get everything you want. Even if the process was trying, it's going to be trying. Litigation is trying. People forget that the sort of the amount of trying this, the amount of pain still in the litigation is much greater, but it's a pain that people can understand. So the mediation facilitation is a pain that people are not as familiar with, so they're more reluctant to get into it. And also, even if parties were hoping for others to be punished more, and I mean it, people are they really want somebody to be punished, but as part of the process, that's again part of the mapping. Well, okay, but what is the punishment going to cost in terms of the of your own, lack of peace over a long period of time in most cases? And that is because you usually get your most important needs met, and that's, right? That's the idea of mediation. You still are going to get your most important needs met because you focused on nuances, relationships, and pressure points. You address deeper issues of leverage and accountability, politics, really, and being deft about politics. I'll mention a little bit more. A lot of times, what the most sort of important thing that you can do is just to get on the board, and that's the last thing. Not only is it the most important thing, but it's actually the easiest thing. But people just are mortified at the notion of getting on a board because it makes them accountable. So, and lastly, because you strengthen the community's current capacities. And you really did. And a lot of times people are, again, they're terrified to do that. So let's go to next slide. I'm going to keep us moving. So, how do resolutions tend to go? So, nothing I'm going to say here is a surprise. They can be long, costly, and painful with a defined endpoint that everybody focuses on. But that's not always at the end of things because, particularly in an HOA, the relationships are still there. And I'll use if I have enough time, I'll give an example about that. It wasn't litigation, but where it could have. So on the mediation facilitative side, one-time disputes can usually be resolved through situation-specific mediations. Larger, more persistent issues usually call for political or social engagement. Again, and this is where people in the mapping process have to decide, they have to take a deep breath and say, am I committed to this? And that's what I can help them do is really a lot of times I'm a political consultant, and there's a process that you go through and people have to decide, and sometimes they're just not. And they walk away or they come back later when they see that it's intractable. So, like I said earlier, they get on or get involved with the board, they participate on a project in which they work with the board and they realize maybe they're not so bad, or if the board truly is, demonstrating a level of malfeasance, maybe they organize, maybe they develop a slate and get on the take over the board, basically. Okay, next slide. So in pursuing your options, all options have a cost. Some options have a better payoff, and some really have that greater cost. Let's go to the next slide. Um, so this is a slide actually Melinda suggested putting in. So who wants to be the first to stick his neck out? And so the example I want to give. Go ahead and move it to the next slide. But I want to do. I'm going to give myself what, 2, 3 more minutes? Okay, so I want to give 2 examples of some of the things that I talked about. One is this was a high-rise building out by the beach, and they had a leaky swimming pool. And it was right on the ocean, right on the west side. And one of the owners came to me and she said, you know, I think that there may be something going on between the board and the professional manager that we hired. And I also think that they are just incompetent and negligent, and maybe there's some malfeasance going on. And so, you know, and she had actually been on the board. And in the conversations we had, she would not, she ultimately didn't want to go into mediation. But what I did was I actually sort of ghost wrote or co-wrote a memo with her to the board talking about the importance of certain compliance issues and why she had a concern about them. And we laid them out very specifically. She had already created a certain amount of ill will on the board just with how she had approached it. And so she was the owner coming to me. Had the board come to me, the conversation probably would have been a little bit different. Um, I might have even persuaded her to do, you know, some of what David Sterling requires in terms of requesting a formal mediation, submitting a formal request, but she didn't quite want to do that either. So, okay, so we did this the dispute consulting. And so what happened was eventually they actually pulled themselves together a bit. And as a result of it, she was able to build her own credibility with some of her other neighbors who saw that she was actually pulling herself back and addressing the problems in a different way. Eventually, she wound up selling, but what was interesting is this process itself made it easier for her to sell because it sort of tamped down and addressed the board issues that were happening. Let's see. Can you go on to the next slide? I think that might be this might. Okay, so go back to the last slide. The other example I'm going to give is an HOA where one of the owners came to them because they didn't like how skylight was being installed around their unit. And it was a similar situation. The HOA actually did engage with them over a period of time, even though, and sometimes I do this in my mediations, I'll do what I call sort of a point of law consultation. We'll bring in an attorney. There are people I work with. Sometimes it'll be to two. Sometimes if it's a quick thing, just one attorney. We got a point of law consultation, which we knew how it was going to be. It was that the HOA had every right to do. It was like the bed bugs. They had done their due diligence. But the HOA, for the sake of the relationship and for various other reasons, decided to actually negotiate with this person. And eventually they did the solution. And what happened was the person who had originally brought up the issue basically became a better neighbor. And this is what I got reported back. And not only that, but they kind of realized their mistake. This obviously doesn't always happen, but this is the point about how mediations can make such a big difference in all of these types of situations. So with that, thanks very much.
And here is Noah's contact information. We will have the ability, if anyone is interested, to get a copy of the slides. But trust me, from being in real estate as long as I have, Noah knows his HOAs. So thank you, Noah. I really appreciate it. Next up is Jack Gannon, who will speak about landlord tenant.
Thanks, Melinda. So during this section, we're going to talk about, some of the dispute resolution options, and Noah touched upon, some of them and the pros and cons. Then we'll really focus on the benefits of a mediation and how that works. Some common disputes that are in landlord tenant. And then a little bit deeper on security deposits, because there's a couple new ABs that have gone into effect back in July and one coming up again. And then talk a little bit more about, small claims parameters in terms of the process and so forth, which is very specific. Okay, next slide, Melinda. Okay, so how the mediation process works for landlord-tenant disputes. I'll mention it again later on, but almost 95% of lease agreements have a mediation or arbitration clause in that. And later on, we talk about voluntary or involuntary. So with that clause in a lease, that does require both parties to make a good faith attempt at mediation. If one of the parties does not agree to that, if it's in the lease, then that can be used as evidence in any kind of small claims or litigation. Once the parties do start the mediation process, keep in mind that the plaintiff and the defendant can be either a landlord or tenant. So a plaintiff could be a landlord going after a tenant for lack of payment and other items, or the plaintiff could be a defendant that is going after, security deposits that were deducted from them and they did not receive. So it can go either way. Either way, the plaintiff has the burden of proof of demonstrating the evidence. The outcome of mediation, of course, is to reach a settlement agreement. And we'll talk in a few minutes what the benefit is to a plaintiff and a defendant to enter into a settlement agreement. Okay, Melinda. So, Noah touched a little bit upon this, just, here's some of the options. I'm not going to go through all of them. So, litigation, probably the least desired, but people often gravitate towards that. The parties are really giving up any input in terms of how to resolve the dispute. The court is going to rule specifically just on evidence. There will tend to be one winner and one loser. I think the misnomer I often find is that whether it's in litigation, is that the court will not act as a collection agency. So if the court awards the plaintiff X amount of dollars, it's up to the plaintiff to be able to collect that money, which comes into play of another benefit of mediation. Arbitration, think of it as that's a private judge. The parties are still giving up really the power to be an active player in creating that settlement agreement. It may be a bit faster than going to court. The courts in the LA court system are backed up at least 3 to 4 months right now for your first hearing. But there's also a cost with arbitration. So the parties, or however it's specified in the lease, have to pay that litigator. Now, mediation is something completely different. This is a process that both parties come together with the goal of reaching a settlement agreement, and both parties feel like they're somewhat of a winner. The mediation can be very creative. It can be creative in terms of the demand amount, payment terms. The settlement agreement is confidential. It's binding. And really, as I mentioned, the benefits are for the plaintiff, there's a higher propensity that the defendant's going to meet the terms of the settlement agreement, because the defendant, if they don't meet the terms of the agreement, that agreement can be brought into court. So the court will then enforce again, and they will have a judgment against them. No one wants a judgment against them. It will pop up in a loan document, anything like that. So, and mediation, is very timely. Again, LA courts are minimally 3 to 4 months minimally for that first hearing. But mediation can be much more efficient from a timing standpoint. Okay, Melinda. So is mediation voluntary or mandatory? So again, remember I mentioned that 95% of the lease agreements out there have a clause requiring mostly mediation or arbitration. So it technically, in those cases, it's not voluntary. You've signed a lease agreement and you've entered into this contract, so you're going to be required to make an attempt in good faith. Those 5% that do not have that as a clause of their agreement, both parties have to agree to the mediation process. So if one party, if it's not in the lease and one party does not want to mediate, then you won't be able to mediate. Okay, Melinda. So, common disputes. So non-payment of rent. So tenants may be struggling financially, seeking some sort of resolution to try to avoid eviction. Property maintenance and habitability. Is the landlord making timely repairs? Is the unit habitable? And that's often around mold, leaks, things like that come into play, that the party is saying, this is not the unit, I want to rent, and it's inhabitable and I cannot live here. They may be seeking restitution in terms of rent relief, or they may want to be getting out of their lease agreement. Lease violations and terms of the agreement. This primarily settles around things like there's an unauthorized occupant in the unit. And oftentimes it comes up where there's a pet in the unit. I don't want to go into real depth about pet and support and service animals. Each city has many different rules, but the crux of it is if someone is claiming a support or service animal, there are about two questions the landlord can ask, and they cannot ask specifically, well, what disability do you have? Once they have to allow them in a no pet residence and have them there, they're now called animals, and the landlord cannot be requiring any type of pet deposit. But I do recommend people go online and look at that city and get more specifics because this can be very blurry in terms of pets. And then security deposits. There's always disputes about security deposits, whether the amount deducted, the timeliness of it, and so forth. And we'll talk a little bit more in a second about things that are changing. The other piece to keep in mind is effective January 1, tenants used to have 5 days to reply to an eviction notice. That's now been extended to 10 business days effective January 1. And some of these things are new, and as Noah alluded to, they're evolving, and landlords are not aware of them. And when they, are not aware, they make mistakes, and that becomes evidence against them. If they actually go, it comes into play in a mediation, but also come into play, in any kind of litigation. Okay. Okay, we talked about pets and service animals. So amount of security deposits. So AB 12 went into effect on July 1, 2024. With that, landlords can only require 1 month security deposit for units, whether furnished or unfurnished. The exceptions are if the landlord has more than 2, but less than 4 units, then they can require 2 months. There are several workarounds where landlords will put multiple units into an LLC to keep it under 4 units. So there is some creative things that landlords do that are lawful. Come July 1, 2025, AB 2801 goes into effect. And there's 2 components to that. One is photographic documentation. Many landlords already do that, but it's now very rigid in terms of timeline. So landlords now have to provide photos of the property's condition before it is the tenants move in. They also have to take pictures of the move in and move out, especially if there's going to be deductions at the move out. And they have to keep it on record for 4 years. So it can be electronic or paper, but they have to keep it on record. The other component of AB 2801, there needs to be a move-in walkthrough. So, I'm sorry, move out. So 15 days, at least 15 days prior to a tenant moving out, landlord must extend an invitation to do a walkthrough of the unit and take pictures of the unit also. So we've added now another set of pictures. The reason for the 15 days is the landlord is being given, I'm sorry, the tenant is being given opportunity to cure on their own. The other pictures in terms of the move out and so forth still come into play. Now with the pre-vacate walkthrough, once the tenant leaves, additional deductions can still be made against that security deposit. So I think about you're doing a walkthrough with the tenant 15 days prior, and then when they move out, they move their couch, and now you're finding the carpet's all ripped. So it doesn't limit that additional deductions cannot be made. Nothing's changed about the 21 days. All deductions greater than $125 need to be detailed. And if the 21-day deadline is missed, the tenant is eligible for the full security deposit. What I find comes up often is landlord will say, well, they didn't give me a forwarding address. That doesn't hold. So landlords need to send that itemized list and any security deposit check returned to the last known address. That last known address could be the unit in the landlord's building. The hope is that the tenant has given a forwarding address so it goes there, but at least they've made good faith attempt. Now, the recommendation that I would give to landlords is within the 21 days is either take a picture of putting it in the mailbox using FedEx and have it dated or certified mail. But you want to make sure you can demonstrate that you met the 21-day deadline. And the deductions are still the same. Nothing changes, as before. We all know normal wear and tear is not one of them. Okay, Melinda. We've talked a lot about mediation versus litigation, so I won't rehash that. Can you conduct mediations in person, virtually, or both? So the answer is yes. So mediations can be done all in person. They can be done virtually, or they can be done as a hybrid. One party's on virtual, one party's in person. So that's, again, a conversation you would have if it's outside the court. You would have it during a pre-mediation conference. It's a little challenging, the LA court system. The courts are trying to figure out how we can mediate when one party's on LA Court Connect and one party's present. So it's a challenge we are trying to work through because so many people are still using LA Court Connect when they go to court. Okay, Melinda. How long will it last? Typically, from my experience, is that landlord-tenant disputes can be resolved within 1 to 3 hours. It rarely goes longer than that or in multiple sessions unless it's extremely complex. There's nuances that make it challenging to mediate right then, or there's multiple parties involved. And so that's about the only situations I see anything longer than 3 or going over to an additional session. Okay, Melinda. All right, so these are some parameters regarding small claims court. Can you file a claim, a landlord-tenant dispute in small claims court? Yes. I see many, many, many of them. File necessary paperwork with the court. So one of the biggest downfalls or issues I see with small claims is proper service. Plaintiffs need to be reminded that there's a 2-step process in terms of service. One is the actual service to the defendant, but also that proof needs to be provided to the court. So many plaintiffs miss the second step, and that just extends the process longer because you start from scratch again, and then you're waiting another 3 to 4 months to get your court date. Evidence exchange. Some courts are a little more flexible, but evidence exchange between the 2 parties should happen a minimum of 10 days in advance. If something is not exchanged, I inform parties you need to exchange it in the hallway or outside because nothing can be presented to the mediator or to the court unless both parties have had the opportunity to review. And then, just something interesting coming on with LA Court, and my court is a beta test, is digital evidence. So this hopefully will help this process. I think they're going to try to roll it out by June. Maximum 12,500. Yes, that is the maximum small claims court. It went up recently in 25. Remember that whether it's in mediation or in the court, the plaintiff can never be awarded any more that was filed in the small claims filing. So if they file for $6,000, that's the cap. They can't go any higher than that. And remember, the court's always going to award based on evidence provided. Mediation can be much more creative. Litigation is all evidence-based. That's it. The court's not going to want to hear any kind of story. Mediation can be much more creative, as we all know. You can be creative on the demand, payment plans, and also sometimes it's very important that there's some non-monetary items that could come into play that helps get to a solution. I did a court case the other day where part of the settlement was defendant had to remove all the negative Yelp comments regarding their service. That's very important to parties. So, okay. And again, the court is not a collection agency. And I have to always remind you, because that's oftentimes a way that you can get parties to get into a settlement agreement Because as I mentioned, higher propensity to meet the terms of the agreement versus court, they make an award and say, good luck, hope you get your money. Okay, Melinda. So settlement agreements. So settlement agreements are, both parties come together to the terms. It is a binding contract. Almost 99% when doing the settlement agreement, it's without prejudice. So that court remains jurisdiction over that case if the terms are not met. And we've talked about, the benefit to the plaintiff and defendant and not a collection agency. Then the STIP is the settlement agreement that gets recorded with the court. People often ask, is that public? No, that's confidential. It will just note that a settlement agreement was reached and will not give any of the details of what that settlement agreement was. And Melinda, I think I'm done, right? Yes.
This is you.
If you have any questions, this is how you can get hold of me, advancedmediationsolutions.com.
And now I am pleased to introduce Annette Berger, who, again, Senior Vice President of Sotheby's and my boss, who I adore. So Annette, the floor is yours.
Okay, there's a lot of confusion out there about the new, oh wait, I'm looking at how do buyers and sellers, landlords moving forward. That's not our slide, is it, Melissa? Melinda?
Well, it is, and you know what, I
Okay.
can sort of, there was just two things that I wanted to share on this.
Okay,
One, as an active realtor, there are 18 forms and they all talk about mediation. Every single form by California Association of Realtors states you must try mediation first. Here, this top line, which I've highlighted, is the same in all 18 contracts. The parties agree to mediate any dispute or claim arising between them out of an agreement. It doesn't mean they have to come to a settlement, but they do have to try. Those are my, now here, this is
Okay.
where Annette is coming on.
okay, I was like, wait a minute. I'm here to kind of explain how we got to where we are now in real estate with buyer representation agreements and how it affects buyers and sellers. So there was a Sitzer Barnett class action lawsuit filed against NAR and all the major companies. And it was a small group of home sellers in Missouri who felt it wasn't fair that the sellers pay all the commissions and even for a buyer. It was very difficult for us in California because our contracts have always said commissions are negotiable. They're never the same. But because we work for major corporations, most of the big players, Melinda and I work for Sotheby's, but that's anywhere. Anywhere owns Coldwell Banker, Sotheby's International Realty, ERA, Better Homes and Gardens, Corcoran Group. It's one of the largest conglomerates in the United States. So the original lawsuit, Anywhere, not Berkshire, Remax, and Keller Williams. Berkshire didn't settle, but Anywhere settled our company and Remax right away for $58 million. So our company in particular has a different agreement in this commission dispute compared to other competitors. Right now, there's many lawsuits that have come into play. Many of them don't affect us, but the one thing that is affecting everybody across the nation is we all must use representation agreements now to show a buyer a home. So our company, we have three different buyer representation agreements. One is a blanket agreement, that covers for 90 days. One is for a single party. And then one is a non-representation agreement at all. And that's the agent actually agreeing to show the property with no commission, but we must have an agreement to show a property. How it's affecting our buyers and sellers is in many different ways. We as a company firmly believe that sellers should pay the commission. And the main reason why is most buyers do not have the funds to come up with their down payments as well as pay their broker's commission. Regardless, it's a negotiation through the process. So right now, if you're a buyer out there, you should anticipate your agent explaining the rules of that they need to sign an agreement before a house can be shown. We are lax on the rules a little bit. CAR has changed them to where, at first it was the minute we had contact with the buyer, we had to have an agreement signed. Now they're saying as soon as the offer process. But you may be asked if you go to an open house, do you have a buyer broker agreement signed? And the main reason there is, we talked about fiduciary. We all have fiduciary in our businesses. And we have a fiduciary obligation to not overstep an agency, boundary with another realtor that may be in contract with another realtor. So we go to great lengths to see if you have signed an agreement with another agent. And that kind of protects everybody through the process as far as agency relationships. Our sellers, we have some sellers, they're, I don't want to pay any buyer's commission. Okay, and they're going to move forward in the transaction saying, I'm not paying it. And so the agents either have to be really good negotiators to where the offer is really good and the seller wants to pay it, or the buyers are paying commissions. A lot of our transactions, we're explaining to the seller, if you don't want to pay commission, then we need to look at appraised value. Our appraisers are looking at who's paying commission. So if the seller all of a sudden doesn't want to pay, let's call out a 2.5%, and I'm just saying that's an average, it's all negotiable. But let's say the seller's offering 2.5%. If the offer's not really all what they want, they may turn around in their counteroffer and say, I'm not paying the buyer's commission. And sometimes we get into the negotiation to where the price will be lowered instead of the commission. The buyer will actually pay it. Many lenders now are financing commissions through the transaction. The fires, man, we've had a lot of fires, right? From Camarillo to Palisades to Franklin, whatever. How the fires affected us in particular, especially our Malibu and Palisades markets. We had several transactions that were in escrow. Many of them, were supposed to close that week. When something like this happens, the seller is required to allow the buyer, even though contingencies have all been removed, it's now new information. It opens contingency periods again. And so the buyers that were affected by this and sellers, we had to kind of maneuver through because the buyer needs the opportunity to see the property, to bring in their own inspectors again, to kind of ask the seller what they want to continue with the transaction. And the most troubling thing was getting to the properties, right? It was very difficult to get in to see the condition if they weren't burned to the ground, so to speak. And so, in essence, we had many transactions where they were canceled. We had some transactions where the seller just wanted to take care of smoke damage. That's all the buyer wanted, was the smoke damage being taken care of. And then that produced all of a sudden the buyer's insurance bond getting canceled prior to closing. So insurance is a huge issue with fires. We've moved through the initial effect of them, and now many are just moving to being on California Fair Plan. It is very important to have any kind of insurance in my mind. I think the worst story I heard, and it was a family of ours, 2 children they had, and they bought a home for all cash in the Palisades, $5 million, and decided to go self-insured. They moved in on Monday, their house was burned down on Tuesday. So, insurance, even if it's fair plan, if we're in a high fire area out here, it is truly important. And many of our clients will move to fair plan as well as putting a backing of Lloyd's of London behind it to get full insurance. Many others will go self-insured, so that's kind of where we're moving. One of our biggest issues with the fires is the leases. And I'm sure many of you have heard about all the price gouging. It has affected us in more ways than one, especially in our Malibu market, because Malibu has properties on the beach that will go in, let's say, 30,000 during a winter month and 75,000 in a summer month. Okay, so the rules currently, and they've been changed twice under the state of emergency, but the current rule is if you own a 4-bedroom or more home, your agent can put that home on at market value, as long as it has not been advertised in the last 12 months at a different rate. If you've been on the market in the last 12 months, then you have to go at that rate and cannot go over 10% if it's unfurnished or 15% if it's furnished. If you're looking at, what Melinda put up here is the HUD guidelines that we have to follow. It is all by zip code. You can ignore the 4-bedroom now because we're off of that, but these are the schedules we're using. So for instance, she has highlighted 90210, our Beverly Hills area, which has also become a huge issue. Now, keep in mind, this is state of emergency. So these rules are not in play just for county by county. It's the state. So in particular, Beverly Hills was the first one that hit us really hard. So as you can see, if somebody has a 3-bedroom home in Beverly Hills, they're saying $5,010 a month. We can multiply that if it's unfurnished by 160%. We'll land roughly in the 8,000 range. Most of our clients' houses lease for 25 to 30,000 a month in the Beverly Hills zip code. So many of our clients are very, very upset about this. We are too, but unfortunately, it is the law. It's the penal code. And they have increased fines in LA County to $50,000 per incident. That goes to a seller or a company or an agent, as well as up to a year in jail. They have arrested 3 realtors at this point for price gouging. We as a company have received several letters, even if it's, let's say, $40 over. Let's say an agent miscalculated a bit. They're following this law to the letter. So don't get mad at your realtors if they're trying to keep you out of jail. We're just passing on the law and trying to explain where we're at. They could change it again. Currently, right now, the state of emergency goes through, I think it's July 7th. We believe it may go on for a lot longer, and we're just comparing it to what happened up into our Sonoma market. In our Sonoma market, we were under a state of emergency for 4 years. So we do not think this is going to be lifted. We are hoping with all of our messaging up to the Attorney General that they need to look at their pricing guidelines for our clients, because we're trying to open up homes to fire victims. Many of our clients want to, but they're not going to go way under market on their properties to open up their housing. This gives you an idea of the Ventura County. The fascinating thing we found about Ventura County, we had a property we wanted to go onto the market, a 3-bedroom in Oak Park. That HUD rate was about $2,000 over the market rate. So these HUD zip code guidelines for us have been a nightmare. So if you need more information on this, a lot of it is on the HUD site that you can look it up.
And I would like to thank everyone for participating. I will stop sharing, and if we have any questions, we are happy to go ahead and answer. Do I have anything? My chat is clear. Bouvier, do we have any questions?
I do not see any questions.
Okay, perfect. Well, I want to thank my guests. You guys were all so informative, helpful. And if anyone wants to know any further information, please contact Bouvier or myself, and we will be happy to get back and answer any questions. So I thank you, and I appreciate. Okay, have a good day, everyone.
I also just shared the slides in case anybody wants it, I put it in the chat as a
Oh,
PDF.
perfect. Okay, very good. Then I will stay on just for a moment. And I think we're good.
Melinda, I think
Okay,
you have
thank-
one question. I think you have one question in the chat.
I just have a thank you.
Oh, okay.
And you are welcome.
Have
Thank you, guys.
a great day,
Okay.
everybody.
All right, bye-bye.